Sir, I've read your motion and a lot of the attachments. Most of the stuff that you sent in involves stuff that happened before the last court order.
Yes, but it's to show a pattern of habit over the last 2 years.
Oh, well, unfortunately, it's irrelevant to this motion because I need something that happened since the last order for a look at parenting time at all.
That's fine. There's other things that did happen since then.
Well, yeah, but there's nothing here that would require a look at parenting time at all. You don't meet any legal standard under the case Shade versus Wright.
She's moved out of state.
She's not moved out of state according to her response. Did you read her response?
No, I didn't actually see a response from her, but she has.
The response is she has not moved out. Are you still receiving your parenting time?
I am, yes.
Okay, that's kind of it. Has is this child in school?
They are.
Okay, school changed?
Well, no, but she still moved. It doesn't have anything to do with the school.
Has everything to do with the school. If she's taking the kids out of state, she can go out of state and visit somewhere if she wants.
I didn't say she took the kids out of school.
Well, that's what matters. As long as she can do with her life what she wishes, as long as everything in the order is being followed. She can't leave the kids with anybody but her. So I'm assuming her response is she's not moved. She had thought about it, she had talked about it, and decided not to, and she would have to ask this court's permission. The court may let her move, but we may not let the kids move, which would then justify your request for a change of custody. But without her moving, you don't have that change of circumstance.
But she has moved. She comes back for the weeks of the kids as of now, but her address is up there. Her phone number's from up there. She lives there.
She is denying that. What evidence do you have that she moved there?
Her phone number, for one, is an area code from that area. Two, when you look up her name, it pulls up her address, which is actually the address she lives in with Ryan Neese. And three, I know she moved because she's mentioned she has it. She just comes back for now on the weeks she has the kids. She comes back.
She has a home here?
She lives with her mom when she's here.
Okay.
But it's not her home. She just stays for the week. But she comes back
but she takes care of the kids in this area.
Well, her and her mom and anybody else that she can get to help her, yes.
Okay, so nothing has changed. Again, no change of circumstance. Well, legally, I'm sure you do disagree, but legally, I can't grant you what you're asking for. Well, the next portion, you want her name off the property. You're the one who's responsible for drafting the quitclaim deed for her to sign.
That was what the judge told us. He said that she had 30 days from the divorce to get it off, which she did yesterday at 4:33 p.m.
Technically, the rules are that you supply the quitclaim deed for her to sign. That would be the normal.
It wasn't what the judge said, and it was never mentioned. So
I understand that, but that's not normal procedure. So, and I don't see it in the order. I just see that but in any event, if you get the house, you have to do the paperwork. Trust me, I was a divorce attorney for 10 years before I did this job. That's normal. Yeah. Well, you were represented at the time, weren't you?
No, I represent myself.
Oh, that would be the problem. Okay. Never mind, your attorney would have known better. Okay. He would have probably drafted the quitclaim deed along with the judgment, and that would have been. But yeah, under those circumstances, it sounds like your motion to enforce has been granted by operation of the fact that she did it. Which she didn't have to do. It should have been you, but I'm glad it's done. Probably her attorney just said, let's get it done and did it. Ms. Grauman's good for stuff like that, and so she moved that obstacle out of the way. But I as to the requisite change of circumstance to make the changes that you're requesting. If she moves and moves the kids, I get you. That's it. But if she has not moved with the kids and everything's going the way it was, there's no change of circumstance. So I have to deny that motion legally. All right. Okay. Good luck to both parties. Have a good morning.
Thank you, Your Honor.
Would have helped had he have read the response, which shows that she didn't move. And if she wants to spend time with her boyfriend when she doesn't have the kid, that's her prerogative. Anyway, next.
This matter is before the court on the plaintiff's objection to a referee recommend order that the defendant fathers parenting time of 1 week during Christmas break and 2 weeks during the summers. In the event this hearing is being conducted via Zoom, President Attorney Leslie Carr representing the plaintiff, objecting party Jennifer Rice. Ms. Rice is present, and defendant father Jose Adrian is also present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
The court has, the parties have conferred with the front of the court. The court's received the fine recommendation from, I believe, Ms. LaPrade. That seems to cover a lot of the issues. It's recommended that that referee recommend order be adopted but modified. Namely, the plaintiff has the defendant's permission to move the adoptive minor child out of state Michigan. To what state, Ms. Carr?
Your Honor, my client is looking at locations in Georgia and in Florida at this time. Mr. Adrian is aware of that and gave his permission to, basically was open-ended and said wherever she needs to move with the child and it's in the child's best interest, he would agree on.
Is that correct, Mr. Adrian?
That is correct, Your Honor.
So if she moves to Montana, California, that's all agreeable?
Yes, if that's what we need. Like when she comes, I just pay for airline tickets to fly her here when she wants to visit. So as long as they got an airport near.
Okay, so it's okay if she moves to California or the state of Washington, correct?
Yes, Your Honor, yes.
All right. So it's noted for the record that the defendant has no objection to whatever state the plaintiff mother and the minor child move. Obviously, Ms. Rice, important that you keep Mr. Adrian informed of that address once you make that
Always.
change. Is this change going to occur at the end of the school year?
Probably spring break time next year.
Well, why
Within-
this child?
Within 3 months.
No, the court has a problem with that. It's a 12-year-old child. We're not going to yank him out of school.
We have spoke about it, her and I would make sure it was within the right times. I'm
Well, but
very
this
transparent.
This court has a problem. We don't, the court does not believe it's best for a child to yank a child out of school, a 12-year-old. It's not a 6-year-old in first grade. Why can't you wait till the end of the school year, Ms. Rice?
Because of job opportunities. I have a job opportunity lined up.
Well, why don't you come back? Once you get that job opportunity, you can present that to the court.
It can wait to the end of the school year. That is fine.
All right, that's what the court prefer.
Okay.
And if in fact that job can't wait, you can petition the court. But Mr. Pratt, if we can modify his recommendation, the plaintiff can move the minor child out of state of Michigan at the conclusion of the current school year. It's also noted that the parties shall share equally in extracurricular activities as the parties can agree. The minor child is currently involved in softball and basketball. Particularly with this child being actively involved in school sports, the child should be able to finish. We're almost halfway through the school year. The child should finish the school year. The issue of child sports referred to the front of the court for formal investigation recommendation, with each party having 21 days in which to object. And finally, a scheduled hearing before referee McKee on November 18th, 2024 is vacated. That's the recommendation. With the one modification, Ms. Carr, that the child or domicile shall not change till the end of the school year. Is your client otherwise agreeable to the recommendation?
Yes, Your Honor.
Mr. Adrian, do you understand the recommendation, what the court has stated?
Yes, Your Honor.
All right, so the court will adopt the recommendation with the clarification and modification that the plaintiff, Ms. Rice, shall not change domicile of the minor child until the your daughter has completed the current academic year. So that will be in late May or early June of 2025. And if in fact, Ms. Rice, you have a job opportunity that presents itself and they will not wait on that, then you can petition the court. We can always consider a change at that time.
Yes, Your Honor.
Right. Mr. Adrian, do you have any questions for the court?
I do not, Your Honor.
Right, Ms. Carr, do you have any questions for either party?
No, thank you, Your Honor.
Again, if this child was first grade, second grade, maybe not a problem, but this child is 12 years old and involved in extracurriculars, the child should finish the current academic year. Particularly since plaintiff mother has no specific job offer opportunity to present at this time. All right, so the court will adopt the recommendation as modified. Thank you, Ms. LaPrade. Now we'll conclude this hearing. Everyone can zoom out and have a good rest of the day.
Thank you, Your Honor.
Thank you.
Your Honor.
Welcome.
And that
Thank you.
updated recommendation is in your queue.